Hey folks, Michael Ayala here. Thank you so much for joining Legal View for our Weekend Review video. Today's a little bit of a special Weekend Review video because there's also some updates that I want to bring to you as well before I send you off to look at some of the videos that we did this week to get you caught up on that. But yesterday, today is Sunday, yesterday the judge, Michael Chittle, in the motion for a new hearing in the Karmelo Anthony case returned his decision denying the motion for a new trial. He did not give any reasonings or any kind of writing. He just said it is denied. And not a surprise. It was a very much an uphill battle from the very beginning. For those of you who have been watching, I've been telling folks, don't get your hopes up on this one because in this post-conviction phase, these motions have a very low percentage of being successful. You need something truly egregious to win at this level. So nothing to be angry about. I've got a lot of notes from folks and messages from people saying how, disappointed they are in it. And I said, don't be disappointed. There's a lot that happened in this motion for a new trial that I think is very important. It's very important going forward. I think the defense team accomplished what they wanted to accomplish with this, and I'll explain. First and foremost, they won the motion to recuse. So they got the folks in Collin County to look at what's going on or what the judge did, something that we all felt was odd and probably wrong, and he got a slap on the wrist for it. It's interesting because what we also found out was that there's a little bit of collusion going on. There's an old boys club in Collin County. The judges had all decided, no, we're not going to have cameras in Collin County, even though the Texas legislature, who represent the people, said that cameras are something we want in this state. But Collin County said, not here. No, they got together and they decided we're not going to do it here. What other little agreements? This is what the things that makes you think about. What other little agreements do these guys have? These little gentlemen's agreements? Is that part of a little collusion? This is how we do things in Collin County type thing, right? We heard Bill Wirskye talk about he's done these before. So you have to ask yourself, is this business as usual there? I'd love for someone to go in and do some sort of deep dive study on the cases where Bill Wirskye has done these gentlemen's deals. Call him in. Make a list of the cases that he's done these gentlemen's deals. Talk to the attorneys. He said he's never had a problem before, but I'd love to know what those deals were for and what types of cases they were on and who the defendants were. I wonder if you'd see any patterns, because the more I think about this deal, the more I don't like it from either side. I had been defending the defense, and I'm still sort of saying the defense, I get what they were trying to do if the deal was as they thought it was, which that Karmelo Anthony would testify. But as I go over the testimony in this hearing, and again, I didn't listen to it. I got it from various sources. WFAA, the Fox station as well, out there were providing blogs about what was going on in the courtroom, but fairly good blogs. And part of the testimony was from Bill Wirskye, the prosecutor in the case. If we didn't have this deal, we would have had to have done all these motions. Bill Shook said the same. Toby Shook, his old buddy, was also the defense attorney in this case, along with Mike Howard, who's part of co-counsel, said if we didn't do the deal, then it also would have meant a lot of motions to figure out what could have come in. The stuff they had on Austin Metcalf, the stuff they had on Karmelo Anthony, there's all these motions. So I thought to myself, I said, so we're talking about the life of a young man, and you're trying to cut your workload? Was this about not wanting to do a bunch of motions and a bunch of hearings? And then with the testimony at the hearing, it sounded like yes, but the reason for it was they were really trying to keep things secret. Because if you have hearings on, okay, what can we bring in on Austin Metcalf? Guess what? Can't close the courtroom. There'll be people in there reporting on it. And all the stuff that you're trying to keep away from the public would have come out in those hearings. So it's all thought of keeping this whole thing secret. I mean, the whole thing just stinks on every level. So there's that. And we found this out. All this stuff comes out. So unfortunately, if things don't work out for Karmelo, maybe now there's eyes on Collin County, eyes on Bill Wirskye, so that people are looking closer at what they do and what they don't do. And as for Judge John Roach, I promise you, that taking him off the case, based on what I heard and know, that was a slap on the wrist by the folks in Collin County. They're like, look, man, we do our thing here. But what we don't do is we don't go on TV right after a trial. We don't want cameras in Collin County. Judge Roach, you can't then just go on camera after a case and start spewing all this business. And I bet you they said, look, we need to show him and others a lesson. That's how you keep people in line. That's how you keep cabals. That's how you keep collusion going. It's really that simple. And as again, I think about that deal, same thing. It's like this judge, this prosecutor, and these are the defense attorneys. When you think about it, four white men, getting in a room and making a deal based on the life of a young man, it rankles. Did the defense have the best of intentions? I don't know. Sounded like they did. They stepped up at the hearing, told their truth. Did Bill Wirskye? I struggle with that one a lot more as to whether this was really about trying to get a fair trial, because like I said, you cannot tell me that if you're trying to get a fair trial, that did not include Karmelo testifying. Because if the defendant doesn't testify in a self-defense case, he's got very little shot. If all they're going to hear is your side of the story. The defense said, we looked for some witnesses and people were hiding from us. Everybody under the tent were friends with Austin and Hunter Metcalf. Wirskye knew this. He knew the struggle. Quite frankly, I think the defense knew it too. I don't know. Again, decision, I don't know. It leaves me feeling a little weird. But let's get into what's the positives here. Before this motion for a new trial, all of this information I'm talking about, the reasons why they decided to not or restrict public access to the trial wasn't on the record. Again, this is Collin County. This is the way they do things. I guess Wirskye was very comfortable with it, which means Judge Roach was comfortable with it. He didn't have any issue with it. Later on in the trial, when Wirskye said, my deal didn't include Karmelo Anthony testifying, the judge wasn't even surprised by it. He just said, I can't do anything for you, defense. Now tell me what you're going to do. He gave him 30 minutes to decide, which really, folks, as I've explained before, is about 10 minutes tops, because it takes 10, 15 minutes to get out of the courtroom and 10, 15 minutes to get back in, right? When you get everybody out and everybody in. So if they had 10, 15 minutes to talk about the decision of his life, he gave him 10 minutes or so. So he wasn't upset at all. The defense, they were screaming. Even Toby Shook said on the stand, he was screaming at Bill Wirskye when he found out that that's what Bill thought this deal was, that Karmelo Anthony couldn't testify. Judge didn't bother him at all. He didn't look at the prosecutor and say, are you kidding me, Bill? Are you kidding me? As many times as we've tried cases together, you think a deal that doesn't allow the defendant to testify in a self-defense case is a fair deal? Do you think that's a fair interpretation of what you guys discussed? Bill Wirskye said on the stand at the hearing, we decided not to put into writing. He was asked by Attorney Russell, why did you commit this to writing? He said, well, there were so many aspects to this deal. It would have been a fool's errand. It would have been so nuanced in terms of what you could do, what you couldn't do, what would open the door, what wouldn't open the door. It wouldn't have made any sense. Now, as an attorney right there, if I've got a deal that is so nuanced that I can't even reduce it to writing, that's not a deal I'm doing unless it's reduced to writing. It's like, that is common sense. There's too many things that could go wrong. And if you don't have it memorialized, what recourse do you have? These are basics. First year out of law school, people would know. So again, I continue to struggle with all of that. But again, let's get back to the positives, right? Positives are that now all this information about what happened with the gentleman's deal and what happened with restricting public access to the trial is now on the record. Previous to this, because it wasn't on the record, none of it could be considered by an appeals court, because what an appeals court does is they don't hear any new evidence. You could not have written any of this in a motion and had the appeals court, I believe it's the Fifth Circuit, and consider it. They only look at the four corners of what's on the record. This hearing now becomes part of the record so they can look at the way this was all handled. This decision to restrict and this gentleman's agreement. Prior to this hearing, they would not have had to do, and these are two important grounds where they say Karmelo Anthony was denied a fair trial. There are going to be others in the appellate process. The Babson issue is one. So that was the real victory here. I mean, victory one was getting Judge Roach out. Victory two was getting out all this information about how things are done in Collin County and how Bill Wirskye does his business. And I just want to reiterate, nothing about what he did was illegal. These agreements happen. Sometimes smaller things, there'll be stipulations, there'll be different things. But when you're talking about the right of someone to testify, if you in your mind are making a deal so that someone would not be able to testify on their own behalf in a self-defense case, all bets are off. That's not something you make a deal about. There's a proper process for that. We're talking about someone's life where they could do up to 99 years based on the statute. And again, he thought he was doing him a favor because if he brings all this information in, 35 years, he thought the way he talked about it in the hearing, it would have been much, much more. Maybe he's right. I don't know. But I can tell you this, there would have been a lot the defense could have done, offset a lot of that. Psychologist's testimony, Karmelo's testimony, I think they could have kept some of that stuff out. Karmelo's knowledge of who the Metcalfs were, all of that really would have played, I think, in this case. So you just don't know. But again, there were positives. This information is now part of the record. It will be considered. I think it's still difficult, especially on these two issues, because at the end of the day, the most important thing and the biggest mistake in this trial was A, not putting it on the record, and B, agreeing to it while it wasn't on the record. Because what Judge Kittle did, I think, was look at it and say, I heard all the testimony, whether he liked it or not. He asked Karmelo's appellate attorney, he said, but didn't the defense agree to this when he was making the arguments about the security and restricting public access? And he was talking about the gentleman's agreement. Didn't the defense agree to this? And he had to say yes. And that really, folks, ends the discussion. Judges are not going to look back and say, I'm going to substitute my judgment for the judgment of the attorneys at the time of the whole thing. Remember, Wirskye said, we did all this stuff restricting the public access for safety reasons, to keep everybody safe. The defense heard what was going on and they agreed. So they thought it was the right thing. So I'm not sure how that's going to play out in the long. But this is a very long process. It's just beginning. I can't even tell you when the appellate briefs will be filed. I've got to look up all the deadlines, et cetera, et cetera. There are deadlines for filing that appeal and when that appeal has to be heard within certain time limits. So we'll figure all that out in the days to come. But don't feel bad. This was an expected loss. And I got to tell you, I hate to be the bearer of bad news twice, but my understanding is the statistics to overturn homicide convictions in Texas is about 4%, 4 in 100. Will Karmelo be one of those 4? Couldn't tell you. There's a lot here, and there's a lot of feeling that this was not the right thing. But if it doesn't work out, let's just hope some good comes out of it, that people look closer at Bill Wirskye and the way he conducts his business, Collin County, and the way they conduct their business. And some of this old school backdoor wheeling and dealing is stopped. So look on the bright side. So this week, most of the things in our week in review have to do with the Karmelo Anthony trial. Some of the stuff earlier in the week, sort of getting you caught up on the beginnings of the hearing. And then as the week goes on, the revelations about the backgrounds and the troubles of Austin Metcalf, the victim, and the troubles in the background of Karmelo Anthony, and all those revelations. Just an incredible week as far as that goes. And then ultimately ending with yesterday's denial of the motion for a new trial. Wedged in is an interview I did with Seth Stern, and he is a First Amendment attorney. We talked about the Don Lemon case. It's a case that I've been fascinated with. It's a case I'm very interested in because it has to do with journalist involvement and reporting, especially in this day and age with independent journalist Don Lemon reported on a protest in Minnesota in January, and he was charged under the FACE Act, Freedom of Access to Clinical Entrances Act, which includes stopping people from worshiping. This protest took place at a church. So the federal government, who's been very critical of Don Lemon, who's been very critical of the administration, the Department of Justice went after him under this act. A lot of questions as to whether that's even a constitutional claim, as to whether the claims that they're making of conspiracy, that he conspired with the protesters to create this protest so he could cover it or help them along with it. He's filed a motion to dismiss, and I'm pretty certain that motion should be denied. But that's a wonderful interview. The guy's super, super informed on it. It's been his battle for the large part of his legal career. So definitely check that out if that's something that interests you. But there's a little snippet sort of in between all the Karmelo stuff this week. So definitely, I hope you enjoy it. Truly appreciate all your support. I got a big week coming up this week. Beginning of the week, I talked to a pathologist who used to work with the pathologist who did the second autopsy for Ben Crump & Co. on Nolan Wells. And she talks about some of the misconceptions and some of the things that's going on around that whole autopsy controversy in terms of what was given over for the second autopsy, what was kept, some of the pressures that are on coroners and forensic pathologists in cases like this. There's a lot of questions about the forensic pathologist in Mississippi finding certain rulings when it comes to the death of young Black men. So are those things possible? Can you fudge results? some of the pressures that you feel to come up with certain results. So really interesting stuff. So that's coming up next week. So I hope you enjoy this particular week in review, and let's hope for a wonderful week next week, and we'll see you all then. Again, thank you so much for your support. This is Legal View, where we look at the news from a legal point of view. And it was stated in an affidavit by Mike Howard, and I believe agreed to by Bill Wirskye, the prosecutor in this case, that he was the one that came up with the idea. He went to the defense and said, basically, let's try this case. Let's try what he called a clean case. Let's not include any of the extraneous information about the victims and about the defendant. Apparently, based on police reports, when they did interviews with people at the scene, there were some negative things said about the victim in this case. They certainly had a background that suggested some things about them and their background that might have been something that would have been admissible against them. The prosecution claims that they had 70 pages of social media posts and school disciplinary records. I don't know how it broke down. That apparently showed Karmelo Anthony had a fascination with weapons. So there was this inducement by the prosecutor saying, look, we won't do that. You won't go after our guys. Let's keep it to what happened under the tent. Those were those words. At least that's according to Mike Howard. That wasn't disputed by Bill Wirskye. What was disputed by the prosecutor was that the understanding of what that meant. So Bill Wirskye puts on his case. He's allowed to make a number of, I thought, objectionable questions, the judge made a couple of questionable rulings that should have been objected to, and they weren't. And I began to question why. Are they throwing this trial? Turns out there was this agreement, so things that were said that should have been objected to, leading questions, perceptions that I thought could have been objected to, were allowed to stand. And the defense at that time was operating under the premise that we're not going to go after your guys when we cross-examine them. We're not going to cross-examine them on their statements to police, where they talk about the victims in the case and what kind of guys they were. We're not going to object when you're trying to get your information out. But they believed that that basically meant that Karmelo Anthony would be able to testify. Well, after the state finishes their case, and they had free reign to ask the questions they wanted to ask, present the evidence they wanted to present, came time for the defense's case, and they made clear that they intended to put Karmelo Anthony on the stand, and the prosecution said, whoa, wait a minute. The deal didn't include putting him on the stand. If you put him on the stand, I'm going to go after him. Problem with that is that now the defense can't go back and go after the victims in the case. People say, well, maybe the background of those guys wouldn't have been allowed in. But Texas has specific laws that might have allowed a lot of that evidence about the victims in. When there's a question as to who the initial aggressor was, and I think that was been a fair question here, then evidence of the victim's background can be brought in. We can hear the actual words of the judge. Now, this was an interview done with WFAA. FAA did comprehensive coverage of the trial. Remember the standard, right? The standard is, if the words said by a judge, these extrajudicial statements, would make a reasonable person think that he could not be impartial when hearing the motion for a new trial. Part of that motion for a new trial is that he didn't give enough public access, right? And that there were some issues with some of the decisions he made. So let's take a listen.
Like I told you before, as long as I follow the law, I sleep well at night. And I'm telling you, I follow the law in that case. Did I know what the perception was going to be? Sure. I knew in the back of my mind what the perception was going to be. But I'm not here to satisfy perceptions. I'm not here to satisfy agendas. I'm not here to do any of those things. I'm here to follow the law. And I did it to a T.
So, Judge, I don't have a problem with what he said.
You do or don't?
I don't. I mean, that's legitimate. And I like the way he phrased it. The reason it's right is because they listened to the evidence, they were in the courtroom, and juries get it right. The problem is not the sentiment. The problem is the fact that he publicly said it.
Right. Right.
And the rules in Texas, and you're a Texas girl, they discourage judges from speaking when their court still has jurisdiction over a case. And his court still had jurisdiction over that case because he knows that these post-conviction motions were coming.
Yeah, that's the problem. I agree with you. The way he said it was fine. If he was doing a talk not on a specific case, but rather on juries and jury selection or doing a CLE, and he made that statement, excellent. If he chose to make that statement about in general with criminal trials, this is what I find in my experience, great. I think the problem is he said that about a specific trial that's still fresh and the appellate process has not run out. I agree with Texas saying be very careful about making any statements about a trial during the appellate process because, okay, he said that. But here's the problem. What if they appeal on some grounds that they win? And that has to do with maybe they get new information, and this did not happen. I'm just saying theoretically, perhaps they learn something new, discover new evidence that a juror was biased or failed to disclose information on the questionnaire that it was a problem. Any of those reasons could cause a court of appeals to reverse and send it back down. And as a result of that, now you have a judge saying, but the jury got it right. I think you are correct. It's the context of saying it during the appellate process about this specific case that makes it problematic.
I think, Judge, in my estimation, this is one of those motions to recuse I think has some legs. What do you think?
I think it definitely has some merit. It's also now, do you not grant the motion, he stays on the case, and you're perhaps borrowing more trouble, or do you, to make it clean hands, go ahead and grant that motion? I think out of an abundance of caution that I would probably, based on what we know at this moment, grant that motion.
According to the attorneys, Austin was made to go to a church group about being consumed by anger and addiction and lust in December of 2024. Howard said that there was potential evidentiary items to contradict testimony that Austin was calm during the encounter with Karmelo and that Austin had a history of wanting to fight. Now, I can tell you in the motion for a new trial, it's mentioned by Russell Wilson that Austin Metcalf, one of the guys who witnessed this, gave a statement to police that this was the norm for Austin Metcalf. He said he had seen this type of thing many, many times before. There's more evidence presented to the judge that included messages from another football player saying that Austin and Hunter needed to control their emotions, and Austin responded with an obscene sexual remark. There was a video from 2022. It was presented to the judge, taken from Austin's phone, showing him laughing at and filming a black student who told him to stop. Austin then hit that kid in the face. It's another incident. Another video taken from Austin's phone in 2023, showing that Austin was hitting a student sitting next to him in class in the back of the head. So all this, it shows Austin was a bully. He liked to fight. He had anger issues, lust issues. Other videos from Austin's phone showed him fighting another kid while wearing boxing gloves and bare fist fighting someone in his room while another person counted down. The defense had another video from Austin's phone taken in January of 2023. It showed Austin cheering on his friend as he tackled and chased a black boy around a house and called him racist names. A separate video showed Austin choking another kid in the weight room. Other character trait evidence presented to the judge showed Austin using racial slurs and holding a butterfly knife while swearing at another student and telling him to come blank or F with me now. And here's the key to the whole thing. I mean, if all these incidents weren't enough, to tell you what we all assumed was the situation with Austin and Hunter, Mike Howard said on the stand, now everything I said to you is what Mike Howard testified to, he was going to present or try to present as evidence against Austin Metcalf. Howard said that Karmelo Anthony once saw Austin and Hunter get into a fight with a kid at a basketball game and could describe knowing that at least one of the Metcalf twins was aggressive and prone to starting fights. He said this showed that Anthony went under the tent knowing that the twins had been aggressive in the past. This is huge because when you start talking about this type of evidence coming in against a victim, one of the key tests is it relevant? And a lot of it wouldn't have been relevant if Karmelo Anthony had no idea about it. So that would have made it more difficult to get a lot of this information in. But if there was information that Karmelo Anthony knew that these guys were aggressive, had actually seen them be aggressive, then it has a higher probability of being allowed in at trial. So this is bombshell type stuff. It also raises the question as to why a defense attorney would agree to a gentleman's agreement that would have precluded all of this stuff, or even precluded the opportunity to get this stuff in front of a jury? I don't understand it. Well, I had said back when the trial was going on, back when we first found out about this gentleman's agreement, I had said, we have to wait and see what the prosecution had against Karmelo to understand the decision made by the defense to agree to this gentleman's agreement. So we're finding out more about what the prosecution had, and that's what we'll get into now. As far as Karmelo's decision not to testify, Wirskye said Karmelo was originally going to testify and then backed out. And we know this, right? We knew that happened. Here's what he said about that. He said it would have been the cherry on top for the prosecution. I don't know why he didn't testify. I wish he had. Then he goes on. He has an explanation based on the information that he had against Karmelo Anthony as to why Karmelo Anthony brought the knife to the track meet. This is important because this was the question. I think if we all came away with one question as from that trial, it was, why did Karmelo Anthony have a knife? Why did Anthony bring a knife to the track meet? Wirskye said he explained that on the morning of the stabbing, Anthony's ex-girlfriend went to an assistant principal at their school and reported that Anthony had been stalking her. Wirskye talked about some text messages found on Anthony's phone. Among them, Anthony sent a picture of the knife that was used in this case and told his ex-girlfriend, I'm low-key on the verge. So that's a nasty threat. That's a nasty threat. He's a 17-year-old boy. According to Bill Wirskye, he's breaking up with his girl. She says he's stalking him. It was bad enough, whatever was going on. I don't know specifically what was going on, but it was bad enough for her to go to the school and say, he's stalking me. He says, I will kill, this is Anthony in his texts, I will kill his butt. Another word again. I will murder that N-word. Wirskye keeps saying all of these things he would have introduced during the trial, and it would have been death by 1,000 cuts. And I can't disagree with him. If I'm a defense attorney representing Karmelo Anthony and this stuff is out there, it's problematic. And the only argument I could make is that when we see Austin Metcalf stuff, he had stuff that was really happening. He was bullying people. He was hitting people. It was happening in real life. This is all text messages. And that's not to excuse the ugliness of the text messages. When you put them together, it seems terrible. There are time frames here. So there might be a text in 1 month, June, then there was another text in May, then a couple in October. So it's happening over a time span. Something might have upset him. So I would have emphasized these things to the jury, that these are text messages. These aren't things that are really happening. But just as a father, as a human being, he seems like a troubled young man. These are not thoughts you want your son having. And he's obviously struggling with something. He probably needed to talk to someone. But again, this doesn't seem to be happening in real life, any of this real, serious violence that he's talking about. In November of 2024, actually, there's an incident report where Anthony took a gun and a knife to school. Saw the same gun situation with Austin Metcalf, fascination with guns. Austin Metcalf made threats with guns. Doesn't say here that Karmelo Anthony made any threats with guns, but he got caught with a gun and a knife in school. Not good. And so the way Bill Wirskye characterized it, he said, when put all together and then you know how the story ends, which is with the stabbing of Austin Metcalf, he says these text messages take on a different meaning. And I can't argue with him. Again, I would try to undercut some of that argument, but he does seem like a troubled young man who was on a crash course to something really bad happening. You know, and I know, you are what you think. You are what you do. And if this is the kind of stuff he's thinking, it's only a matter of time before he acts out on it. Was it that day? I don't know, but that's certainly how prosecutors would have wanted to make it seem. And it wouldn't have been that hard with this stuff. There's more texts. He texts his girlfriend, "I want to effing kill you, B word." He wants to stick that rifle in your mouth and claim PTSD. There's other texts. They didn't go specifically into them, but apparently Bill Wirskye said there were texts about drug talk, robbing people, physical violence. There's actually a video of Karmelo Anthony driving by a house and pointing a gun. Although it's a still image, I didn't personally see it, but the reporter reporting on it says you really can't 100% tell what exactly is going on in the picture, but that's how it was characterized by Prosecutor Bill Wirskye. I want to talk about this, whether this could get into evidence. There's a question as to what could come in. Character evidence or evidence brought in like this to show that he's a violent kid and therefore it proves that he acted violently on that day. Or he had a penchant for violence, so he had a penchant for violence. That's character evidence. That's not allowed. But it can show within a context a state of mind. That's an exception. Prosecutors would have said all of these texts work together to suggest this was the state of mind of Karmelo Anthony. You put that in with the text and the situation with his girlfriend on the day of the stabbing. I think it's a pretty good argument that a lot of these texts within that time frame, 2024, perhaps as far as 2023, would have been allowed in to suggest the frame of mind of Karmelo Anthony, which makes it a very, very difficult case for him. So Shook assumed that this gentleman agreement was something that was a good thing for both sides. And he felt when Karmelo Anthony testified, it meant that prosecutors wouldn't bring that up in cross-examination. And from the defense's point of view, testifying in a self-defense case was completely necessary. So, these are assumptions. And again, I've said before, I don't want to judge the defense based on the decision to do this with all that they had on the victim. Because number one, there was no guarantee that the information they had on Austin Metcalf would come in. During testimony today, he was asked about that whole thing, and he said, look, all it meant was that we would have to have a series of hearings as to whether all that information could come in. And again, he also knew, and it came out on testimony today, he knew that Bill Wirskye was someone who enjoyed doing cross-examination, was good at cross-examination. And Bill Wirskye, when he was asking him, he said, you know how much I love to cross-examine murder defendants. And Toby Shook said, yeah, I know what you like. So again, these attorneys know information about the judge, the likelihood of things happening based on their experience in the jurisdiction, experience with the other attorneys, that we can't substitute our judgment for. So I will not judge them for deciding that this was the right deal. Because if you think about it in terms of the way the defense thought about it, was that Karmelo Anthony would not be cross-examined on all the stuff going on during his day, it was a good deal. Because again, the thing that we had questions about, and I'm sure the jury had questions about and never got answered until this hearing, was why Karmelo Anthony had the knife. And the prosecutors were going to argue he had it because he had this issue with his girlfriend. He even texted her this picture, and that's why he was bringing it. You could even say maybe he was thinking about hurting her. That's extremely damning, because now you have an actual reason why he brought it. And you could even have an actual reason why he might have been in a very weird emotional space. Maybe even looking to lash out at other people for whatever problems, whatever emotional issues he was having because of his girlfriend. So I think it would give prosecution a much more concrete, because I said from the beginning of the trial, from opening statements, they made that statement that he left the house that day with his knife in his bag to go look for somebody to hurt. And I was like, where are they getting this information from? This goes into another part of the motion for a new trial with the provocation defense. I won't go into that here, but the defense claiming that there wasn't any support for the provocation defense because there wasn't any evidence as to why he would have went to the tent to hurt somebody. The prosecution had this larger story to tell, and by making this deal, they didn't get to tell it. So I can see where the defense thought there was this benefit to both sides. So I'm not going to dispute that making the deal was a good deal if you take into account that Karmelo Anthony could testify. The government suggests that he was involved in meetings beforehand. And here's where I sort of had my struggle. If he was involved in meetings prior to, where is there a line for journalists? So they're saying they met at some undisclosed place with some people and they talked about the protest. He was aware of the protest. I didn't see, and maybe you know, I didn't see anything in that that suggested he was the one that put the idea in their head or said something like, okay, you guys do this. That'll help me because I can cover it and I can get better coverage. I'll get better ratings or whatever. So talk to me about that aspect of it. If in fact there were these meetings, would that have been crossing the line? Like, where is that line where there might have been a problem in terms of his involvement with the protesters?
Right. No, I don't think that joining meetings that are part of the planning process in a journalistic capacity with the intention of being able to better cover the news story, to cultivate sources, is in any way evidence of participation in a conspiracy. Had it been sort of a tail wagging the dog situation where he manufactured this protest to give himself a story, and had the protest itself been unlawful, maybe that's a different conversation. Had he provided supplies for the protest? We've seen cases where journalists were alleged to have carried the spray paint that people later used to vandalize something or other at a protest. Maybe that becomes a different story. Had he operated as an activist rather than a journalist, and by that I don't mean his editorial slant, that's fully constitutionally protected, but had he been, again, an organizer of the protest, that might be a different story. Of course, it might also be constitutionally protected. It really depends on the precise facts. The First Amendment is intended to be construed broadly to give maximum breathing room to press freedom and to discourage any sort of prosecution. And contrary to sometimes popular belief, the First Amendment does not hinge on a reporter's objectivity or neutrality. Reporters are allowed to have opinions.
Okay.
So absent an act in furtherance of the conspiracy, that's really the basic legal element that's missing here. This protest was going to happen with or without Don Lemon.
Right. And his support of it is not criminal in any way, as you just said. But let me ask you, they also allege, and they backtracked on this and said that this was not true. And I think it was contained in the original report that they got that said somehow these journalists were chanting along with the protesters. So talk to me about that. And we'll assume it's true. It is not true. And they've already said it's not true. But had that been a part of this, would that have been something that crossed the line? Or is that just, you're allowed to have a point of view?
It would have been a more difficult case if they were actually participating in the protest, only because under that circumstance, you might be able to make an argument that they did intend to disrupt the worship that was taking place at that church. I would still make constitutional arguments in their defense. I would say that an application of the act to prohibit constitutionally protected protests on matters of public concern, particularly in circumstances that can be dealt with through ordinary trespass laws, would be constitutionally problematic. But yeah, it's fair to say that actually participating in the protest would add a dimension to the case that doesn't exist under the currently known facts. And that's probably why the government attempted to sneak it in there without any reason to believe it was actually true, as this government so often does in criminal complaints. Under the FACE Act, that would add an element of perhaps there was an intent there to disrupt versus an intent to cover news.